Thank you, Mr. Chairman. And I'd like to thank the witnesses of this panel today for their moving testimony and for sharing with us their experiences and their struggles, their work for public safety, for justice, for civil liberties and civil rights. The role of an Attorney General is not to be a bystander or a mere witness to the passing of time. Fundamentally, the top law enforcement officer of our country has an obligation to enforce the law, but that is too simplistic a framing. In a world of limited resources and competing demands, not every violation of law is enforced equally at all times in every situation. And the Attorney General of the United States has enormous power to shape the strategy of the Justice Department and deploy its resources of $27 billion and 100,000 employees. And at times, we heard yesterday a more moderate, a more reflective Senator Sessions, who gave encouraging answers to a number of pointed questions. But I'm very concerned that Senator Sessions' 30-year record reflects many extreme positions, far out of the mainstream, not just of our legislative work here, but out of the Republican Party. And more than that, I'm concerned that Senator Sessions' record demonstrates when there was an opportunity to stand up for the vulnerable, to promote civil rights or advance justice, he did not take action or even actively oppose bipartisan work that would advance justice. So I have just a few quick questions. First, I'd like, Mr. Chairman, to introduce into the record a letter from Coretta Scott King that was sent to the chairman and ranking, at that point Senator Biden, back in 1986, that was apparently omitted from the record, that I think ought to be made a part of the record. And I'd like to first ask, if I might, Dr. Brooks, about Senator Sessions' record. He's been criticized for actions he took ranging from the 1980s to the current day. And based on his record, many have expressed concern that as Attorney General, he might not fully enforce a variety of civil rights laws and help advance them. And after the Supreme Court's decision in Shelby County striking down preclearance, the most important piece, I would argue, of the Voting Rights Act, a Voting Rights Act that was really forged in the crucible of the march in Selma, a number of us worked to try and find a fix that addressed his concerns about the formula being outdated, that the formula was based on things that had happened decades ago. And despite diligent, disciplined work to try and find a bipartisan solution, we did not find a partnership with him. Tell me, do you believe that Senator Sessions, as Attorney General, would not just be a witness to actions, but would act to advance justice?
Based upon the record, we don't believe that. And the reason being here is that the Voting Rights Act has been debilitated in the wake of Shelby. We've seen these voter ID laws affecting at least 21 million Americans. We've seen these voter ID laws based upon the false predicate of voter fraud. We saw that in Alabama. We have not heard the senator speak out on the voter suppression in his own state. A voter ID law in that state, or similar to the one in Alabama, has been invalidated both in the Fourth Circuit and in the Fifth Circuit, North Carolina, and Texas. The senator has referred to the Voting Rights Act as I should say, the debilitation of it as good for the South. He's referred to the Voting Rights Act as intrusive. He has not spoken in any way commendable. Has not done anything to strengthen the act in the wake of Shelby, has not recognized the voter suppression in his own state, has not spoken out in any way significantly in terms of the voter suppression that has occurred in the wake of Shelby. So we have no reason to be confident that as a chief law enforcement officer of the country, that he would do all that is necessary to protect the rights of Americans. In other words, being a prosecutor is not merely a binary matter. You do it or you don't. There's a matter of discretion. There's a matter of judgment. It's a matter of allocation of resources and a matter of using the resources of the Department of Justice to bring about justice. We have no reason to be confident that he will do that.
And to make it clear, Dr. Brooks, Senator Franken was just asking about this. The allegation that there were 3 million fraudulent votes in this last election was made by the president-elect without any foundation. We have had hearings in this committee. There have been hearings in other places and in other legislatures. There is no evidence of widespread fraud to justify the voter ID statutes that have been enacted and subsequent reviews, not just in North Carolina, but in other places, have found them to be unconstitutional, yet the nominee for Attorney General has been silent about those issues and concerns. Is that your case?
That is in fact the case. And let us note this. Let's just be very clear about this. Empirically speaking, one is as likely to see the tooth fairy standing next to Santa Claus at the ballot box as to encounter an actual instance of voter impersonation, voter fraud. Those are simply the facts. And so for this kind of voter fraud to be a predicate for voter suppression is a shame in our democracy. There's no such case of voter fraud on the magnitude that has been described by the president-elect.
Thank you, Dr. Brooks. Mr. Cole, the ACLU has published a report outlining a number of concerns about Senator Sessions' nomination, ranging from voting rights to criminal justice to LGBT rights to torture to religious freedom. And I'd like to note that in the audience today, I've marked Mr. Khizr Khan is here with us. He has spoken passionately about his son's sacrifice for our nation in combat in Iraq, and has submitted a letter that I think is worth review by all members. I'd like to submit it for the record, if I might, Mr. Chairman. Mr. Khan, in his letter, spoke about his Muslim faith, about what it means to be an American, and what it means to have real concerns about the Attorney General nominee and his commitment to the enforcement of religious liberty and protection of civil liberties. Out of all the issues raised by the ACLU, what concerns you most?
Well, I think it's the pattern. It's the pattern of abuse when he exercised prosecutorial power, and the pattern while he was senator of not just an ideological difference, as some have put it, but of blindness at best and hostility at worst towards the interests and the rights that the Attorney General of the United States has a responsibility to protect. So when you say, you can vote against the Hate Crimes Act, but when you say the reason I'm voting against the Hate Crimes Act is because I don't think gays and lesbians and women are victims of discrimination, that's a blindness. When you say Islam is a toxic ideology, that's hostility. When you defend the president, when he proposed, the president-elect, when he proposes a blatantly unconstitutional action using religion as a test for immigration, and you in the Senate are one of 4 people who defend that position and oppose a resolution that does no more than underscore what the Establishment Clause requires, which is that government officials be neutral vis-a-vis religion, that gives us great pause. So I think it's the entire set record here. It's not an individual disagreement. It's about a failure to recognize discrimination and a hostility to some of the very rights that the Justice Department is designed to protect.
Thank you both for your testimony. Thank you, Mr. Chairman.